Quickly moving on, how do we mitigate the risk, right? In March 2023, US Department of Justice issued a guidance, and they said that their guidance was to the US prosecutors to say that if a company that they are prosecuting for FCPA has a certain elements in their compliance program, then they should consider that to the credit of those companies, and they should treat them with a bit more considerate view. They may allow them to do their internal investigation. They may allow them to negotiate the penalty. They may give them due consideration for the efforts and investment that company has taken. And therefore, it is important that it has become almost an essential requirement for all the US MNCs to have a global anti-bribery compliance program. Now, this compliance program is not one-page document. It is not one paper. It is host of various initiatives, and that initiatives must be based on certain elements that I'm going to walk you through. I'm aware of the time, so I'll probably move a bit fast, and hence please make note of your questions. So your compliance program has to be based on the risks such as what are my products, right? Who are my customers? What is the bribery risk? Because typically a bribery risk for a healthcare company when they are selling products in hospitals or laboratories will be different than bribery risk of a chemical company whose customer set is different versus a bribery risk of a telecom company or a heavy industrial company, because the product is different. The way the business is done, is it B2B or B2C? Is it a government business or a private business? Whether the business has certain requirements to offer products on loan, on lease, or there is a buy and sell transaction. Depending on all of that, where are those pain points, temptations, or pressures for our associates and executives to get into a misconduct, right? And where is the risk? So the compliance program has to be designed to make sure that your business risk is plugged and program is actually tailored based on your business risks. Secondly, there has to be proper, not only global code of conduct, clearly stating what instances of bribery are prohibited and what is the responsibility of the senior executives, associates, distributors. There has to be proper internal policies for the implementation of the code of conduct. So when there is a customer expense, when there are heavy discounts, when there are free products, when warranties are extended beyond the standard warranty, when there are any off the record transaction is being sought to be made by distributor or any associate or company, when there is a risk of side commitments, all these things, there has to be a proper internal policy and procedure that beyond a certain threshold, a certain type of transaction must be reviewed, not just by a sales and marketing leader, but maybe by a finance leader, maybe by an operational leader, maybe by a legal compliance leader. And the rationale of that particular transaction has to be properly recorded. And every single such questionable transaction must be reviewed by more eyes than just the eyes which may have an obvious conflict and and temptation to go ahead and do that transaction, which might later be questioned. So that internal policy and procedures must be in place and must be functioning, where every single transaction that can tomorrow come under question must be properly recorded and approved. Third important element is confidential reporting structure and investigation process. So a lot of US companies have this hotline. Some people call this hotline. Some people call this speak up line. Some people call this as voice your concern. And this line is typically a 1-800 number, which is available globally. And people from various countries can make a phone call and make a complaint in the local language. It is a free of charge calling line where an employee or distributor or customer can raise a risk, raise a concern that there is a potential violation of FCPA, there is an act of bribery, or there is any illegal activity that has happened at the hands of company representatives or distributors. Now, when this kind of complaint has come, it typically can be made by identifying the person or can be done anonymously. And there are reputed US and global companies who manage the hotline for most of the Fortune 500 companies. And then once the complaint has come to this independent company, then they forward the complaint to the company's chief compliance officer, who will then assign an investigation team, and investigations are done in a impartial way. And this will allow even if senior leaders in particular country, let's say India, are getting into a bribery scheme and they are somehow finding a way to hide it, but a salesperson, a sales rep, or a junior finance person, or any other person sees that this is not according to the code of conduct that I have trained, now that person has direct access to make a complaint. And when that complaint comes, investigation will take place. And through these investigations, then company is able to unearth if there is a scam and take an appropriate action. So whether that kind of structure is there is an element of a good compliance program, right? Investigation process is a good compliance program element. Whether the company has a chief compliance officer who does not report to the MD, who does not report to the commercial team, but who reports to the audit committee or the board of directors, because then there is an independent reporting, and that person can then call a spade and stop all the wrong transactions. And that person has to be empowered with sufficient resources. This is also an element. Is there an investigation team where they can do an impartial investigation? And when you find something wrong, are you able to punish the wrongdoer? And then when you are able to punish a wrongdoer, are you able to protect the whistleblower, the person who brought in the complaint, from any retaliation? Because if there is a protection against retaliation, then only people will show courage and come forward and bring wrong elements. And when those wrong elements will come in the in the surface, company will be able to address it. So clearly spelled out non-retaliation policy and examples of protecting the whistleblowers is also an element of the good compliance program. Now, third-party management, right? When we do business in a vast market like India, we have to work with distributors, third parties, consultant service providers, contractors, right? So when we do that, does your compliance program require you to do a pre-onboarding due diligence? Which means, am I looking at a distributor who has a history of corruption and then avoiding getting into such transaction? Am I looking at examples of questionable transaction by this third party? There are due diligence technologies available where you can check the name of this distributor and the owners to see whether they are politically exposed persons, whether they have been convicted in an offense, and you can run the name of these individuals through the global database search. There are further level of diligences people can take. People can go to the website of the municipal corporation to check the copy of the license. They can check whether the office really exists. So there are different levels of pre-onboarding due diligence of third parties that typically companies would do. And they then train the distributors on the anti-bribery policies. They get the declaration signed, and then they decide to sign a contract and then go ahead with the business. Then it doesn't just stop, as I said, doesn't just stop with appointing a distributor or third party, but throughout the life cycle of my contract, am I monitoring, auditing any anti-bribery practices, helping the distributor or the third party or my partner to build a good control to prevent the bribery are all elements. And most importantly, am I telling my sales team not to pressurize my distributors, third parties to say, okay, company nahi kar sakti to aap kar do, hum aapko discount de denge. Whether that kind of pressure is there or not, and are you addressing that pressure very clearly with your sales team is another area. M&A is the last but not the least. When I'm acquiring a company, am I doing a pre-acquisition anti-bribery due diligence? Am I looking at the target that I'm planning to acquire and say, okay, what kind of business model, how much government business they had, are there questionable business models, are there lack of internal controls, are there excessive discounts, are there more payments to third parties, are there any unethical commitments? And if otherwise the product quality and the business model is profitable that I'm going to acquire, then I'm also inheriting the risk of bribery. And when that risk is inherited, tomorrow if there is a prosecution or action taken on that company, as an acquirer of that company, I also need to then make provision to deal with that risk. But am I accepting this company as a part of my acquisition with open eyes? And then there are experts who are helping companies with this kind of due diligence. Do I have a solid integration plan where I apply my anti-bribery program to an acquired company? I specifically plug the risks that are identified to a due diligence. Am I doing proper training of the employees and distributors of this new acquired company? Am I trying to make an effort to implement my culture into this new company? Am I giving this clear message to them that if the business was done in a particular way, now that game is no more on. This company wants to do business in a clean way, and they have to follow these processes, and they need to bring to us if they have any risk, right? Am I making those efforts after I acquire the company? Is there enough training and communication? Do I have case study based trainings that is imparted to all my distributors, associates, employees, etc.? Is my program based on real life examples? Am I giving only a theoretical training, or am I giving them a training that they can apply in their day-to-day business, right? Are my commercial leaders acting as speakers in these trainings? Because when the commercial leaders are asking distributors and employees not to pay bribe, then there is a huge impact versus a legal and compliance training, team doing that training. Do I have a system of communication where if I have terminated an employee or distributor for a wrongdoing, on a no-name basis, at least I am communicating the type of transaction that is not acceptable that can result in termination? Am I creating that awareness when I punish a wrongdoer, right? Most importantly, tone at the top. No system and no internal control will work unless and until my leadership is committed to do business in a non-corrupt way. It will not work unless my CEO, my MD is giving that clear message to the distributors, to the employees, that I want you to grow the business, but I want you to grow the business in a clean way. If you find a risky business proposition in a particular customer, then don't go, scout for another customer. There is enough customer and there is enough market, but only do the clean business. Even if sometimes you do not meet your target, I'm okay, but I want you to do business only in a clean way. That kind of messaging has to also go from the leadership. That will result in a
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.